So now we see the principle of Audi Alteram Partem, rule of hearing, or we can also say it like a personal hearing. This is the second principles or components of the principles of natural justice. So the meaning of Audi Alteram Partem provides that the hear the other side, or no one should be condemned unheard, or both the side must be heard before passing any order in a particular case. In a civilized society, it is assumed that a person against whom any action is sought to be taken, or whose right or interest is being affected, shall be given a reasonable opportunity to defend himself. It is the first principle of civilized jurisprudence and is accepted by the laws of man and God. In short, we can say this principle is that before an order is passed against any person, a reasonable opportunity of being heard must be given to him or afforded to him. Generally, the maxim includes two elements. The first is notice and the second component is hearing. So, first component, that is notice, provides that a basic principle of natural justice is that before any action is taken against anybody, the affected party must be given a notice to show cause against the proposed action and seek his explanation. It is a sine qua non of the right of a fair hearing, and any order passed without giving a notice is against the principles of natural justice and is a void ab initio. Now, only the notice is issued is not a very enough. Its adequacy is also required, because it is not enough that a notice in a given case be given, but it must be adequate also. The question of adequacy of notice depends upon the facts and circumstances of each case. It can also be said that the reasonable opportunity must be given. It is to be noted that the notice must be given a reasonable opportunity to comply with the requirements mentioned in it. By only giving a 24 hours time to dismantle a structure alleged to be in a dilapidated condition is not a proper time, or the notice to be declared is not as a void. Second is hearing. The second requirement of the Audi Alteram Partem maxim is that the person concerned must be given an opportunity of being heard before any adverse action is taken against him. In the case of Menka Gandhi versus Union of India, the passport of the petitioner was impounded by the government of India in public interest. No opportunity was afforded to the petitioner before taking the impugned action. The Supreme Court has held that the order was violative of principles of natural justice, because no opportunity was afforded to the petitioner before taking any action against him. In the case of Sridhar versus Nagarpalika, the petitioner was appointed by the municipality as tax inspector. The commissioner set aside the said appointment without issuing any notice or giving an opportunity of hearing. The Supreme Court quashed the order of the commissioner and observed that it was an elementary principle of natural justice that no person should be condemned unheard. Now, this is also covered in two forms, like oral hearing or fair hearing. Oral hearing means a person cannot claim the right to oral or personal hearing unless such right is conferred by the statute itself. In the absence of such statutory requirement, the general rule propounding by the Supreme Court of India is that the natural justice does not necessarily involve a right to a oral hearing. Second is fair hearing. While fair opportunity to be heard should be given to the parties, the principle does not imply, unless expressly provided by the statute, a right to a personal hearing. The requirements of a natural justice are not only if opportunity to represent is given in view of the proposed action. So now, what are the requirements of a fair hearing? Again, a fair hearing requires the following rights, some rights which must be given to the person affected by it. So the first, how a fair hearing can be decided, is the proper way of first point is cross examination. Cross examination is one of the most efficacious methods of establishing truth and exposing falsehood, but it does not necessarily mean that the right of cross examination of witnesses upon the facts and circumstances of each case and to the statutory provision. Second is legal representation. Normally the right of a representation by a lawyer in any administrative proceedings is not considered to be indispensable part of natural justice, as oral hearing is not included in the minima of fair hearing. But speaking generally, it can be said that the right to be personally presented by the counsel has been recognized in the administrative law. Third point is right to know evidence. The right to know the materials on which the authority is going to make a decision is a part of the right to defend oneself. The general principle is that the adjudicating authority must base its decision on the material known to the parties. No evidence can be taken into considerations which has not been known to the parties concerned and for which no opportunity has been afforded to rebut it. The last important component of fair hearing is the opportunity of being heard. The requirement of the opportunity of being heard is a very part of the fair procedure, and any order passed by the adjudicating authority without providing any opportunity of being heard to the party concerned is a bad and can be set aside by the adjudicating authority. So we can say that the opportunity to be heard must be required two things, that is the opportunity must be given and the opportunity must be reasonable. Thus we can say that the reasonable opportunity of being heard should be provided.